client walks into a chiropractor's office, has a manipulation done on his low back that herniates a disc. He was badly injured. And farmers took the position that because it was a medical malpractice case and that it occurred during the provision of professional services, that something known as the professional services exclusion applied, and therefore there's no defense, no coverage, because the incident occurred during the provision of professional services. But there's a hitch. In this case, it was an independent contractor who was providing the professional services. It was not the actual insured.
Once it was established that there was no insurance, we really didn't have any choice but to proceed with taking Michael's personal injury case through trial, getting a verdict from the trial judge, and then getting the rights assigned to us by the defendants, and then filing a subsequent bad faith case standing in the shoes of those defendants in order to try to collect the judgment.
And then we faced a motion for summary judgment against farmers, and the appellate court overturned the MSJ and said there very well might be a duty to defend when the insured is not the one providing the professional services, but rather an independent contractor is.
The insurance bad faith attorney was a very good attorney. And so I would read a brief and be like, well, he made a really compelling argument there. And then, but once you started sort of peeling back the layers of the onion, you could see where they just got it wrong. And as much as they tried to put the lipstick on a pig, we just kept wiping the lipstick off and exposing their arguments for the pig that it was. And it was that perseverance that really, really makes me proud, not just of my firm, but to be a trial lawyer.
I was always taught by my partner and mentor, Wiley Aiken, that if you think about the client, a lot of good things happen. And that kept us going in this case. This client, such a nice guy, such a good guy, such a patient guy, and he'd been so badly harmed. You just wanted to help if you could. And sure, it was a shot in the dark when it started, but ended up paying off.
One person was killed at a Southern California Costco last night when an off-duty police officer opened fire.
It's Saturday morning, it's at Costco in Corona. Officer Sanchez is a off-duty LAPD officer. He's there with his wife and young son shopping. The French family's also there. Russell French and his wife are there with their son Kenneth. According to Officer Sanchez, Kenneth French, who was mentally disabled, he had schizophrenia, unexpectedly slapped or punched him in the head. Officer Sanchez went to the ground and said he thought that he was shot and Kenneth French had a gun. He pulled out his gun, pointed it in the direction of Kenneth French, said he was a police officer. Paola French, the mother, stepped in and said, "Please don't shoot, my son is sick." Russell French said something similar, and then 10 shots rang out.
My mother was shot first in her back, and my father was shot second in the abdomen, and my brother, being the furthest away, was shot 4 times, 3 of which were in his back.
It breaks our heart that he had such a sad end at 32, and then to see both his parents shot.
Now, once discovery started, we got a lot more information that really helped us, such as specific training the officers have at the LAPD, how to handle situations like this when they are off duty, and giving them authority to use force and deadly force.
Because of the civil jury's finding that Sanchez acted within the scope of his job as a police officer, even though he was off duty, unless there's an appeal, the city of LA may have to pay the damages awarded earlier today.
This sent a message to the entire law enforcement community and civil rights community that just because a police officer is not in uniform or off duty or out of his jurisdiction, if he acts based on his training, if he's acting with police officer authority at the time, the very agency who hired him and trained him could be on the hook for all of the damages sustained by the officer's wrongful conduct.
Riot Games is a video game manufacturer. And what the company does is it consistently pays women substantially less than men. And it hires women into lower level positions and keeps them at lower level pay. And the stories that the women told were really disturbing, all the way from initial interviews up through years of working at the company. They talked about a really toxic environment.
This case was about, ensuring that women in the workplace in this particular field, in video game development, and really in tech as a whole, are treated equally. I mean, these are, extremely talented people who, for no other reason than their gender, were being held down.
It's a significant discriminatory practice against women. So we decided that we were going to work with the state agencies, with the DLSE, with the DFEH, because we wanted to do our best to create maximum pressure on Riot Games to be fair in its assessment of the case and to actually hold them as responsible as possible.
We would like to change the hearts and minds of people, but if you can't change the hearts and minds, then the next best way is to make them fearful of their pocketbooks. And I think people are realizing now that this is not a game, it's not a joke. There are people who are going to come after you, and there's going to be a price to pay if you don't change.
There are women in other companies now, in data and in tech and in gaming, who can point to this settlement and say, we have a right to know what our male comparators are being paid. And you have to treat us fairly. You have to treat us equally. We made a huge impact that is going to forever resonate.
There were two founders in Silicon Valley and Stanford who decided to make smoking or nicotine cool again. They developed a nicotine delivery device, an electronic cigarette, that could mimic the speed of nicotine delivery to the brain. This was called the Juul. These products took off among teenagers, but it didn't really accelerate until Altria, the company formerly known as Philip Morris, partnered with Juul, and that catapulted like wildfire Juul's reach among teenagers and young people.
They say right now more than 1 in 4 high school students in the U.S. use e-cigarettes. They also allege Juul not only lured them with ads, but also failed to include required health warnings.
We filed cases in federal courts across the country. They were coordinated and consolidated in front of Judge Orrick in the Northern District of California. He said that we needed to approach this case with the fierce urgency of now. And we took that to heart. Like what happened with cigarettes, it can't take 50 or 60 years to bring these companies to account. We have to do this now because we have to protect the next generation. And then we brought those claims and litigated them all the way through a global resolution with Juul, and ultimately in the middle of trial, a resolution with Altria as well. It's not for the faint of heart to take on a tobacco case. This is the kind of case where if we are going to make systemic change to address a public health epidemic, we have to work together. We were extremely focused on how to build consensus, to build a strong team, focused on the tenets of good leadership, welcoming all ideas, welcoming newer, younger lawyers, lawyers with different backgrounds. And it was that diversity and that strength that helped catapult this case forward and get the kind of spectacular, meaningful relief that we were able to get.
Rising star in the rap world has died. The New York Times reports that Lil Peep died last night before a show in Tucson.
In the news and in other locations, you hear about it in terms of this is the death of this ascendant rap star, Lil Peep. But the case was also about Gustav R., who was just barely 21 years old at the time he passed away. And this case really involves the unbreakable bond between a mother and a son, and her thirst and quest for justice on his behalf.
Lil Bo Peep with a brand new flow too. Looking at my teeth like you never seen a go-to.
He started off kind of making music in his bedroom at his mom's house on Long Island in New York, and over time developed a really fervent online following, and he got noticed internationally and ultimately was signed to a record deal with First Access Entertainment, who was the defendant in this case.
Welcome to Rolling Stone News. I'm Mike Cayazzo. Lil Peep's mother, Liza Womack, has filed a lawsuit against the late rapper's managers for negligence, breach of contract, and wrongful death, among other charges.
I think the music industry in large measure underestimated her will and desire, both to achieve justice for her son, and secondly, to also prevent others from having to undergo this type of issue. The music industry has historically been given a pass under the guise of sex, drugs, and rock and roll, that encouraging drug use, facilitating drug use, profitizing off of drug use, that somehow that was okay. And she had the courage to say it's not. I'm proud of the result that we got. I'm proud of the systemic change that people have already told us has come about by virtue of our lawsuit. No longer are there no rules on tour. No longer do people in the music industry think that they won't be held to account, because this first grade teacher from Long Island showed them that her son mattered, that these young aspiring artists matter, and that business as usual just won't be tolerated anymore, and that justice is blind, and that everyone who engages in that type of behavior can and will be brought to justice.
This case involved two children, age 11, when they were molested by a teacher who taught at Moreno Valley Unified School District, and they underwent a years-long history of abuse, both sexual, physical, emotional. They were threatened, and it was just a never-ending journey that they've never fully recovered from.
Brady Blair reached out to the firm, and I heard this tragic story about a 6th grade boy who was abused for 5 years by his teacher. And I asked him if anyone else knew about this, and he told me about another survivor named Justin. And both boys, who are now 38 years old, they ended up hiring the firm to represent them in this important case. And in discovery, we were able to learn that 8 years before our client's abuse began, the school district had actual notice evidence that this teacher had been arrested for child molestation charges. And even worse than that, when the teacher's credential in the state of California was revoked, the principal of the school went on a campaign, a letter writing campaign, and he encouraged all the teachers to write letters of support so that the perpetrator could get his teacher credential back.
And in this case, we were able to show with a 90% finding on the school that really it's the school that knows these activities are taking place, that needs to screen these teachers, to be more diligent in protecting the students. And when the parents turn their children over to the school, they expect them to be protected in a safe place.
When we fight hard for these clients and we bring about justice, one of the next steps is that these institutions, they have to take acceptance of what has occurred in terms of the jury result. And they do take a second look at their policies and procedures.
I think that more people should take these cases on, and they should take them to trial and to bring to light what has happened and hopefully prevent it from happening to others and make schools more diligent in how they protect the students.